So, good afternoon. Greetings from Geneva. Good morning to those of you joining us from across the Atlantic, and good evening to those from the other side of the world joining us. My name is Bruno Dimmeyer. I'm the editor-in-chief of the International Review of the Red Cross, and it's my great honor and pleasure to kick off this quite excellent webinar I'm sure we will have today with a fantastic lineup of very knowledgeable speakers on the topics of counterterrorism, sanctions, and humanitarian action. Why this webinar? In brief, the three co-organizers of this webinar, which are the International Review of the Red Cross, the United Nations University Center for Policy Research, and last but not least, the International Peace Institute, all within the last few months published major publications on this very topic. These publications were the result from the side of each of the co-organizers of extensive research, and you will be provided in the chat box with a link to the PDFs which can be downloaded free of charge. From our side, the International Review of the Red Cross published this edition on the 22nd of February. It's almost 800 pages long, contains 6 interviews with 2 special rapporteurs from the Human Rights Council, with high-level officials from states and the European Union, no less than 25 articles. So I will not even begin to try to summarize all of these articles. Suffice it to say that we have among our speakers from today a number of the authors speaking and joining us with us. Now, the importance of the topic doesn't need to be overstated. Famously in 1789, Benjamin Franklin is on record to have stated that in life, the only certainties are death and taxes. For all of us working in the humanitarian sphere, I am pretty comfortable to add sanctions and counterterrorism or restrictive measures to that list of certainties we need to live and navigate with. And the purpose of the webinar, which is really you see throughout the 3 publications from the International Peace Institute, the UN University, and our own review, we all acknowledge a great deal has already been written on this topic. And yet, all of the publications try to be forward-looking, to come up with practical, legal, and policy solutions in order to move the debate forward. And the excellent knowledge represented among the speakers this morning is going to accomplish exactly that, I'm very confident. We have an enormous amount of interest from around the world, around 200 people registered for the event, many who could be in their own right, I can see from the named speakers, on the panel as well. You are invited to put your questions in the chat box. Only the speakers and the panelists can see the questions. And once the Q&A is open, the moderator will select the most interesting questions to be presented to the panelists. If you do ask a question, if we may invite you to just identify yourself so that that information can also be shared when the question is being presented. On that note, I will end speaking from Geneva and hand it over to my colleague also in Geneva, Ms. Gillian Rafferty, who is the managing editor of the International Review of the Red Cross and who will be moderating this webinar today. Thank you.
Thanks so much, Bruno. And I just want to reiterate Bruno's very warm welcome to both our panelists, of course, and also to the many people who have joined as our audience today. As Bruno said, we're thrilled about this event, and we hope it'll be a very useful and exciting conversation. And we really do encourage you to participate using the Q&A box. We're really eager to hear what you would like to hear more about from our speakers. At the same time, I want to let you know that in the chat box that you all can see, I've put the links to the 3 publications Bruno mentioned, so you have access to those to peruse them at your leisure. They are each a weighty piece of work, each on its own. So you aren't here to listen to me, you're here to listen to our very esteemed panelists who we are very honored to have with us here to share their expertise and to help us better break down today's topic. To give you a sense of how this event will run, we have 5 panelists, each of whom will present on a few elements of this broader discussion of UN Security Council sanctions, IHL, and humanitarian action. So rather than tell you more about that myself, I'll first turn the floor to our very first panelist, Nazma Dirzadeh, who's the director of Harvard Law School's program on international law and armed conflict. On a personal note, I was lucky enough to get to be a student of hers when I myself was in law school. We've given Naz a heavy workload in her short remarks today, as we've asked her to do two different things. First, she'll provide a bit of the lay of the land, and she'll provide an overview of the legal and policy frameworks that are relevant to a discussion of Security Council sanctions, IHL, and humanitarian action. But after that, we've asked her to also delve into the critiques and analysis that she's put forth in her own article in our review edition, Counterterrorism, Sanctions and War. So without waiting any longer, I'll turn the floor to you, Naz. It's all yours.
Thank you so much, Jillian, and thank you to my very old and dear friend, Bruno de Meyer. Thanks to the UN University Center for Policy Research, the Review, and IPI for the invitation to participate in this, as Bruno said, a very timely event. As Jillian suggested, I'm just going to very briefly outline three contextual elements that I see as informing today's discussion before moving to a handful of observations. And I should just add the quick caveat that I won't be doing any distinguishing between counterterrorism and non-counterterrorism sanctions, though there are very important distinctions to be made there, which I think some of our other speakers will address. So first, as regards the wider context and scene setting, there is a growing base of evidence, much of which has been commissioned by UN bodies, member states, and NGOs, documenting how sanctions and counterterrorism measures adopted by the Council contribute to a welter of detrimental impacts on humanitarian actors. Those adverse effects include security perils, legal endangerment, operational impact, reputational harm, and funding precarity. In numerous armed conflicts, also considered to constitute sanctions and counterterrorism contexts, those detrimental effects may lead to diminished or complete lack of access for humanitarian and medical actors to the persons affected by the conflict, whether those are civilians or fighters placed hors de combat. The restrictive measures may also adversely affect the scope, amount, or quality of humanitarian and medical services provided to these people. It is worth noting, and we can talk more about this in the discussion, that despite the increased range, quality, and number of studies in recent years demonstrating this impact, the very question of adverse impact remains contested by key actors in this space. A second element that I think informs our discussion is the focus of international discourse on UN sanctions regimes and international legal obligations pertaining to humanitarian action. Much of the debate here is often framed in terms of what I see as a handful of questions. First, the structure and content of relations between Security Council sanctions-related decisions on the one hand, and international humanitarian law, which is applicable to situations of armed conflict on the other. Second, the content of IHL provisions applicable to states not party to a particular armed conflict that falls within the range of these Security Council regimes. Third, the relative legal, policy, and practical significance, if any, of references to IHL in relevant Security Council resolutions. And finally, the roles not only of states, but also various other international actors, including the Security Council and certain of its bodies, in interpreting IHL, the content of IHL, when it intersects with sanctions regimes. A third aspect that I see emerging on the debate much more frequently in recent years is the move or the call to move to purported solutions. There are four approaches I see in this arena that come up frequently. The first is a call for dialogue between humanitarian actors and sanctions or counterterrorism officials or representatives. The second approach is to seek, as I said earlier, to prove the adverse impact of sanctions and counterterrorism measures on impartial humanitarian activities, to provide more and more evidence. Third is a response that relates to humanitarians' attempt to appease sanctions and counterterrorism regulators by demonstrating that humanitarians are serious about compliance with these measures, that they are taking more and more steps to comply with these measures. And finally is a response to ground and legitimize the humanitarian imperative by emphasizing that it is especially or even entirely rooted in international humanitarian law. Having laid out some of this background, I'll now spend just a few minutes reflecting some observations in the piece in the review that I co-authored with my colleague, Dustin Lewis, also informed by about a decade of experience in this field. From my view, much of this current debate, which is increasingly turning to the idea of technocratic solutions, is unsatisfactory. A significant reason why is that the discourse is often framed in terms of enhancing the efficacy and bolstering the legitimacy of sanctions and other restrictive measures. In my experience, it is rare for the debate to be framed at the outset in terms of advancing the humanitarian imperative. For many reasons, I think the starting point of these discussions matters significantly. Second, from my viewpoint, much of the sanctions and related counterterrorism architecture is not based on the same normative commitments as impartial humanitarianism, contrary to what we often hear, that all of these regimes walk hand in hand with the same fundamental goals in mind. Indeed, for reasons that we set out in our note, my sense is that at the root of this controversy is a fundamental values clash, not only with respect to the global counterterrorism architecture, but also with respect to the bulk of sanctions regimes pertaining to armed conflicts. To date, all of the pro-humanitarian responses in this area assume, implicitly or explicitly, either that the values clash does not exist, or that if it does, it can be worked around through technocratic means. As I understand it, the humanitarian imperative is based on normative commitments to provide, in all armed conflicts, impartial aid and protection to all civilians in need and fighters or to combat, irrespective of affiliation. Impartiality, in the sense of being driven by the needs of the persons affected by the conflict rather than their affiliation, serves as one of the humanitarian imperative's primary ideological justifications. In this way, the humanitarian imperative embodies deeper and, in a sense, more principled ideas and moral tenets than its textual IHL formulations can express. Thus, while IHL is an important facet of this debate and the surrounding practice, a retreat into legalism invites, in a sense, both a category error and a strategic error. Instead, a finely calibrated balance is warranted, one that underscores the vital importance of compliance with IHL, but does not frame IHL as a cure-all, and instead foregrounds a political claim about what we believe are shared humanitarian values. When seen through a sanctions lens, impartial humanitarian activities are often conceptualized as supporting terrorism or restricted groups. Only in relation to certain contexts are ad hoc, or what we often hear case by case, and limited carve-outs laid down for aspects of humanitarian action. In short, the humanitarian imperative compels activities that numerous sanctions regimes either begrudgingly tolerate or outright prohibit. One way to champion humanitarian values on their own terms might be to reject calls to suppress needs-based aid and protection in armed conflicts involving sanctioned entities. This avenue's relative success or failure may turn partly on making and fulfilling commitments to engage now and looking to the future in normative contestation and political education to rebuild cultures that privilege and prioritize respect for the humanitarian imperative. A second possible course may be to embrace and ground security-centered concepts and frameworks in terms of strict respect for impartial humanitarian activities. A third may be to confront and contest constraints on impartial humanitarian activities arising from security rationales. So to directly challenge the very naming or labeling of certain contexts as terrorism contexts. In conclusion, respect for impartial humanitarian activities is increasingly being framed in terms of whether those services and activities comport with the sanctions architecture. In the process, some pillars of impartial humanitarian activities are at risk of political, legal, and ultimately cultural erosion. From my perspective, it is time to articulate and enact a broader vision that elevates the values and ethical commitments that animate and compel the humanitarian imperative. I really look forward to the discussion. Thanks.
Thank you so much, Naz, for, as always, such unbelievably well-articulated and in-depth remarks. So we're going to change gears a little and sort of flip much more to the sanctions side. Our next panelist today is my pleasure to introduce him. His name is Thomas Bierstaker. He's a professor of international relations and political science at the Graduate Institute here in Geneva. So he's going to speak more from a sanctions perspective on the effectiveness of sanctions and how to address perhaps some of the tensions that Naz raised, while still with a focus on ensuring that sanctions can remain a valuable tool in the context that they've proven at all valuable in. So with that, I'll turn the floor to you, Thomas. The floor is yours.
Okay, thank you very much for that introduction, and thank you to all of the sponsors for organizing this event and giving me the opportunity to say a few words about sanctions. I suppose a more sanctions-centered or focused orientation and perhaps the beginning of engagement with the very provocative and I think very insightful presentation we have just heard from Naz. Let me begin by acknowledging that the challenges facing humanitarian actors operating in sanctioned countries have created, I think, what is the most profound challenge to the legitimacy of UN sanctions since the litigation associated with inadequate due process protections for individuals in the early 2000s. I recognize that in many ways, everyone loves to hate sanctions. There's a standard narrative that they don't work, they target the wrong people, they hurt innocent civilians. But I think it would be helpful to move away from a narrow focus on criticisms of sanctions alone and rather concentrate on perhaps these are the technocratic practical ways to ameliorate the negative externalities that are inherently associated with restrictive measures like sanctions. And I say this because I believe that you could eliminate many sanctions regimes entirely and not solve the challenges of access and provision of relief facing humanitarian actors. Obviously, there are wars going on in many of the sanctioned countries. There are deliberate restrictions applied by targeted governments and non-state groups themselves. There are mandates from donor countries that constrain the activities of humanitarian actors, and other explanations for bank de-risking, such as advice from companies providing name recognition software and recommendations from organizations like the Financial Action Task Force that shape the environment for humanitarian actors globally. So we're in a very complex situation and facing complex problems. Before we dismiss sanctions, however problematic they may be, I think it's important that we also think about the consequences of the alternatives to sanctions, either the use of force or the prospect of doing nothing. Everyone asks whether sanctions work, but few ask whether war or diplomacy work. And in fact, sanctions sometimes do work. So it's important that we stay focused on the conflicts that motivate the different interventions of diplomacy, sanctions, covert action, or military force, and consider the interactions and interactive effects of these different types of intervention, rather than just stay focused exclusively on sanctions. Now, sanctions are often employed to try to minimize and prevent conflict, and they can also be introduced to move parties toward the resolution of a conflict, however difficult that may be. So intervening to prevent or resolve conflict may contribute to human rights and broad humanitarian goals as much as the actions of human rights or humanitarian advocates. As Samuel Moyn has recently argued, war causes more suffering than the violations of its rules, and we should therefore focus not only on making war more humane, but return to fundamental challenge to the legitimacy of war and aggression itself. And if sanctions can play a role in this effort, I think they should be utilized and not dismissed. And I also think it's important to remember that targeted sanctions were first developed to address the unacceptably high humanitarian costs associated with comprehensive sanctions, drawing primarily on the Iraq experience in the 1990s. We seem to have experienced a generational loss of memory about the negative consequences of indiscriminate measures that inflict damage on an entire population rather than those responsible for prescribed policies. And we return to a discourse on sanctions of calling them unprecedented, hard-hitting, crippling, along with the simple idea that strong sanctions mean broad-based, indiscriminate measures. Now, this is an argument that Johan Galtung dismissed as the naive theory of sanctions more than 50 years ago when writing about the sanctions on southern Rhodesia, but it's returned with a vengeance, I think, under the slogan of maximum pressure. Another point I want to make is that not all sanctions regimes are the same. In fact, the strongest critics of sanctions repeatedly refer to the cases of Iraq, Cuba, Iran, Venezuela, Syria, North Korea, now perhaps soon Russia. But there's a real case selection bias operating here in the discourse, and these cases are not the norm in the larger universe of sanctions regimes, particularly when we're discussing UN sanctions. Because most of these cases that I've just mentioned are the products of a disturbing trend away from the application of targeted measures, a trend away that was introduced by the Trump administration in the United States, an anomaly to be sure, but one that it is troubling to note that the Biden administration has continued in many respects. Yet there are many UN sanctions regimes that are far more targeted and unlikely on their own to create the kind of humanitarian challenges associated with indiscriminate sanctions regimes, such as the sanctions applied to Mali, CAR, South Sudan, or Sudan. We can talk about some of the details perhaps in the discussion. So when we think about sanctions and humanitarian action, I think we need to ask ourselves just what are the reasons for the humanitarian challenges faced by humanitarian actors in many conflict situations. One, is it due to the design of the sanctions measures? And I think in some cases, yes, that's true, particularly in the DPRK when we're considering UN sanctions regime. Or second, is it due to the overcompliance and general de-risking by the private sector? Yes, of course, there are examples of this, and they're acting rationally within the existing regulatory system and the active advice they're receiving from other actors. Third, is it because of donor government conditions that go beyond the language of UN Security Council resolutions when it comes to implementation of restrictions described in the resolutions? Or fourth, is it due to deliberate over-implementation by some states, usually regional powers, pursuing their own foreign policy interests like Saudi Arabia and Yemen, or historically the case of Nigeria and Sierra Leone? Now, I ask these questions because I think it's important to think about why we have the problem facing humanitarian actors in order to attempt to resolve it. And the explanations for the challenges facing humanitarian actors, I believe, are both complex and multiple. It's also important to take into consideration the diversity of sanctions regimes and sanctions senders operating in the world today. And most of the examples of broad sanctions regimes that I mentioned just a few moments ago stem primarily from unilateral or autonomous sanctions regimes designed to complement UN sanctions regimes or address conflicts when the UN has been unable to act or provide basic protection. Now, I'm saying all this not because I do not think there's a problem or that there's not a crisis facing humanitarian actors today, but because it's a truly complex environment when it comes to the relationship between sanctions and the activities of humanitarian actors. Let me just conclude this first intervention with a response to claims I've heard in some webinars from individuals about the precedence of international humanitarian law over other legal systems. And I agree that in situations of active armed conflict, such as the contemporary conflict in Ukraine, that international humanitarian law should take precedence. But I don't think this extends beyond the context of active conflict situations. That is, I do not accept the idea that IHL supersedes or takes precedence over other legal systems, such as international human rights law or the law of states. So I'm making an ontological claim that we live in a world of overlapping international legal systems that dialectically contradict, conflict with one another, not a world of a simple or clear hierarchy between or among them. And this means that there can also be complex and moving boundaries between the emergency humanitarian intervention and longer term reconstruction and development in complex conflicts. There's much more to say, but I've used my allotted time. So let me save the further comments for the question and answer and discussion that's going to follow. Thanks very much.
Thanks so much for that, Thomas. I think there's a very exciting first two interventions that present two different critiques of the same system, one that perhaps suggests a more transformative solution and one that suggests a more technocratic one. I want to remind everybody that if questions come up during the presentations, you can add them to that Q&A box at any time. And then we will come back to those questions once each of the presentations has been made, but please don't be shy to add questions as the event proceeds so that you don't forget the questions that you have. While I think there's a lot that we could immediately engage in between those two presentations, we'll power through the rest, and then we'll come back and get into maybe that big debate we've started with. So next, I want to turn the floor to Agathe Sarfati, who's a senior policy analyst at the International Peace Institute. She's going to speak about UN Security Council sanctions in the counterterrorism space and how the Security Council has approached IHL and humanitarian action in that counterterrorism regime. While oh, I'm so sorry, you guys. I've gone out of order. Sophia is supposed to speak first about conflict-related sanctions. My mistake. So Sophie Uve, who's a legal expert on sanctions and international law project at UN University, she will speak first on conflict-related sanctions and how they have considered IHL and humanitarian action. And then we'll turn to Agathe. So Sophie, the floor is yours first.
Thank you, Gillian. Thank you very much for the introduction. I'm very happy to be here. It's always a bit stressful to pass after Naz and Thomas, but I will do my best to march in their steps. I will dedicate my presentation to only UN sanctions regimes which are conflict related, meaning sanctions regimes which are specifically designed to resolve conflict situations, and so I will not talk about counterterrorism regimes. And conflict-related regimes account for the majority of the 14 UN sanctions regimes. So we're talking about DRC, Central African Republic, Somalia, Libya, Yemen, Taliban, Sudan, South Sudan, Mali, and so on. So this is just to give you kind of the broader context. And with that in mind, I would like to articulate this presentation around two main points. The first one is to provide an overview of how UN conflict regimes have considered IHL and humanitarian action in their design. And the second one is to provide a few recommendations to address remaining gaps. So let's dive into the first point. Most UN regimes are applied in the context of armed conflict, where IHL also apply. And this is not a very well-known fact, especially in the humanitarian community, but for the better part of the last 2 decades, conflict regimes have been designed and used as a tool to sanction IHL violations, obstruction of humanitarian access, and attacks against humanitarian workers. It means that conflict regimes are specifically intended by sanction designers to help enforce IHL and protect humanitarian action against the abuses and the violations that can be committed by the parties to the conflict. It's not necessarily the main objective of these regimes, but it is a constant in all of them. So conflict regimes inherently make room for IHL and humanitarian action, and they have done so for the past 20 years or so. So just to give a couple of examples, in practice, all conflict regimes have strong language recalling the IHL obligations of the parties to the conflict, and notably the obligation that they must allow and facilitate humanitarian access. Moreover, the majority of the conflict regimes also include designation criteria based on IHL violations and obstruction of access or attacks on workers. It means that individuals or groups can be sanctioned, so they can be added to the UN sanctions list because they engage in these actions. But for a long time, the Security Council did not take into account the fact that its own sanctions measures could themselves have detrimental effects on humanitarian action. And in a way, it's understandable. If your sanctions are targeted and they're initially designed to uphold IHL and to address obstruction of access, it's almost counterintuitive to think that these same sanctions could also impede the delivery of humanitarian activities, because in a way it would run against the initial objectives of sanctions. So, as Naz said, in recent research, there has been a growing base of evidence recently and a growing base and a growing advocacy movement as well, which has shown that these types of impacts exist, even if they were not intended by the Council in the first place, or even considered by the Council in the first place. We describe them extensively in our report, so I will not spoil it for you, and I encourage you to have a look at it. But anyway, the Council has started to address the effects of its own sanctions measures and try to find some remedies as well. There are three types of measures that have been employed so far. The first one is exemptions. The Security Council has tested a wide range of exemption measures to facilitate humanitarian activities in conflict settings. The most recent one is the standing exemption that was adopted in Afghanistan. But exemptions measures vary a lot depending on the type of regime. They do not exist everywhere, and not all of them are satisfactory for humanitarian actors. And we can come back on this during the Q&A. The second type is the language on compliance with IHL. So the sanctions regimes on the DRC, the Central African Republic, Libya, and Somalia all include language explicitly requiring member states to ensure that the measures they take to implement sanctions comply with their own obligations under international law, including IHL. And this is meant to clarify to states that they have to interpret, implement, and enforce their UN sanctions obligations in a manner consistent with their IHL obligations. And the third type of remedy is what we call the intent clause. So the regimes of the DRC, the Central African Republic, and Mali include language explicitly stating that sanctions measures are not intended to have adverse humanitarian consequences for the civilian population. This is what we call an intent clause, and it has been included just over the past couple of years in these regimes. And this language can be interpreted by member states as a way to ensure that their implementation measures do not prevent humanitarian aid from reaching civilians. So this is a very brief overview. And again, there is much more in the report, but that brings me to my second point. What recommendations can we make now? When we talk about recommendations in the design of the UN regimes, and I acknowledge Tom's point about the fact that there are many other sources of issues for humanitarian actors, but when we talk about just the design of the UN regimes, there is a need to strike a balance between several objectives, notably ensuring that humanitarian actors can deliver their activities in compliance with IHL, protecting the humanitarian actors' impartiality, neutrality, and independence, protecting the effectiveness of sanctions, and political feasibility among the Security Council. The preferred solutions of the sanctions and the humanitarian communities are often seen as contradictory, but we do have to acknowledge that progress has been made over the last 4 years, notably thanks to the advocacy of NGOs, and notably with the few examples discussed before. We explore a wide range of recommendations in our report, and I do not intend to go over them one by one. Again, no spoilers, but I just want to give a few examples of what can be done at the level of the Security Council. For me, the main driver should be to continue to harmonize the design of the conflict regimes. A lot of states do not want a one-size-fits-all solution, especially when it comes to exemptions and standing exemptions, but we can work on the harmonization of the language and of the methodology, and I believe that this is key. Concretely, in terms of language, I will just retake the two examples that I gave. First, the Council should replicate the language on the obligations of member states to comply with IHL across all of the regimes, because for now it exists only in 4 regimes. And second, the Council should reproduce the language of the intent clause across all of the regimes as well. And for now, it also only exists in 3 regimes. Replicating that type of language would both provide some safeguards for humanitarian actors, and we can talk during the Q&A on how humanitarian actors can activate this type of safeguards, but it would also help to reclaim better effectiveness and legitimacy of sanctions for sanctions designers. Let's not forget that UN sanctions are the universal basis on which many other unilateral sanctions are adopted and applied. So it would also send a positive signal, which may be replicated in other contexts as well. Beyond resolution language, the Council needs to dedicate more resources to the monitoring of the sanctions regimes. There is a constant ask from states to have evidence of how sanctions impact humanitarian action before adopting mitigating measures. And even when a mitigating measure is adopted, some states still call into question its effectiveness or the risk of aid diversion that it can lead to. So just two examples of what the Council could do to palliate these two criticisms. First, empower the panel of experts to conduct impact assessment with a common methodology. And second, ask either the Secretariat or the panels to conduct lessons learned of mitigating measures. For example, let's conduct a lessons learned on the Afghanistan exemption, which was adopted just a few months ago. Has it been implemented by states? By how many states? How effective it is to facilitate procurement, financial flows, to reassure donors, and so on. So there are many other recommendations outside the scope of the Council, recommendations for member states, for donors, for private actors. And I'm happy to discuss more during the Q&A, and I believe that Agathe and Leah will address some of them as well. Thank you very much for your attention.
Thank you so much, Sophie, and sorry again for the mix-up in the order before. I know I already began my introduction of Agathe, but just to reiterate, she is a senior policy analyst at the International Peace Institute. She'll talk about UN Security Council sanctions more in the counterterrorism space as opposed to the conflict-related space, and how the Security Council has approached IHL and humanitarian action in that counterterrorism sanctions regime. So with that, I'll turn the floor to you, Agathe.
Thank you very much, Jillian. So yes, my presentation will focus on three main points. First, I'll start to give a quick background on the UN counterterrorism sanctions against Daesh and al-Qaida. Then I'll discuss how the Security Council approached IHL and humanitarian action in this counterterrorism CT regime. And I will end with recommendation, and we'll see that many of those are similar to the one that Sophie mentioned and which apply to the conflict-related regimes. So in terms of background, today, the Security Council oversees one counterterrorism sanctions regime. It is a global sanctions regime which focuses on certain armed groups rather than on a context or a country. Instead, it targets Daesh, al-Qaida, and associated individuals, groups, and entities. There are currently 89 entities and more than 250 individuals listed under this UN regime. Some of these groups listed are parties to armed conflicts, including the al-Nusra Front in northwestern Syria, Boko Haram in Nigeria, the GNIM in Mali, and others. In these cases, IHL applies to all the parties to the conflict, regardless of the fact that these are listed on the UN counterterrorism sanction list. And therefore, rules of IHL governing humanitarian activities also apply. The UN counterterrorism sanctions regime is driven by the intention to deprive the listed individuals and entities of the means to conduct terrorist acts. So all the listed groups and individuals are subject to an asset freeze, an arm embargo, and a travel ban. The asset freeze is of particular importance here because it prohibits the transfer of funds, financial assets, and economic resources to any of these listed entities, in addition to freezing their assets. Humanitarian organizations have noted that the overlap between the asset freeze and the measures adopted by the Security Council to criminalize the provision of funds to terrorist groups have had the most impact on their ability to carry out their humanitarian activities, particularly in areas controlled by these listed armed groups. And the overall impacts include de-risking by the financial sector and the overall chilling effect on humanitarian organizations, amongst others. So now that we have the background in mind, we'll discuss how the Security Council has approached humanitarian action in the regime and how it has addressed these impacts. First, contrary to the conflict-related regime that Sophie talked about, the ISIL al-Qaida regime has not included any listing criteria on the basis of violation of IHL or obstruction of humanitarian access or targeting of humanitarian actors. And we can discuss during the Q&A whether having such designation criteria should be explored by the Council in the CT regime. Second, like the other UN sanctions regime, it is only in 2021 that some safeguards for humanitarian actors were included in the Daesh al-Qaida regime. In December 2021, the Security Council adopted Resolution 2610, which renewed the regime, and it included two provisions it had previously included in sanctions regime of the Central African Republic, DRC, and Mali. That there is an intent clause which states that sanctions measures are not intended to have adverse humanitarian consequences for the civilian population, and a clause which demands that states comply with IHL when implementing the resolution. This is significant headway for the regime because it signals that the Security Council sees no contradiction between IHL, in particular rules governing humanitarian activities, and the CT objectives of the regime. However, at the last mandate renewal, the Security Council fell short of including all the humanitarian-related language featured in its previous CT resolutions or of adopting a humanitarian carve-out, and we'll discuss those briefly. First, on precedential language. In 2019, in adopting Resolution 2462 on countering the financing of terrorism, the Security Council adopted language to better protect IHL and humanitarian activities. In particular, operative paragraph 24 of the resolution urges states, when designing and applying measures to counter the financing of terrorism, to take into account the potential effect of those measures on exclusively humanitarian activities, including medical activities, that are carried out by impartial humanitarian actors in a manner consistent with IHL. This provision was not included into the mandate renewal of the Daesh al-Qaeda sanctions regime last December. Nonetheless, one could argue that this same provision of 2462, which applies to measures of countering the financing of terrorism, also applies to the asset freeze against Daesh and al-Qaeda. It surely would be better to include this provision directly in the counterterrorism sanctions regime to clarify that it indeed also applied to the asset freeze. But arguably, having it in 2462, which covers all measures to counter the financing of terrorism, along with the new intent and IHL compliant clauses in the sanctions regime, provide a strong basis for states to interpret and implement the sanctions against ISIL and al-Qaeda in a manner that is respectful of IHL and rules governing humanitarian activities. On humanitarian exemption, as we mentioned, the UN counterterrorism regime does not include any humanitarian exemption or carve-out for impartial humanitarian organizations. Having a humanitarian exemption in the Daesh al-Qaeda regime will be a big step because the interplay between sanctions and CT measures is what triggered the most adverse impact on humanitarian action. But for several members of the Council, this continues to be a red line because of concerns that the humanitarian exemption could be abused. And I'm happy to go back to this point during the Q&A. This brings me to my last point, which is the need for better guidance on the implementation of sanctions regime, but also the need for stronger assessment and monitoring of the design of the regimes in general. And this could help inform the way forward for the Daesh al-Qaeda sanctions regime. To conclude, recommendation applying to the Security Council vis-à-vis safeguarding humanitarian action in conflict-related regimes could also apply in the CT regime and vice versa. The Security Council has started replicating language that provide better protection to impartial humanitarian action across some of its regimes, including the intent clause and a clause on compliance with IHL, and it should continue doing so for all its sanctions regime. The Security Council could then consider further harmonization in its approach to IHL and humanitarian activities in sanctions regime, in particular, in adopting a well-framed and standing humanitarian exemption in its CT regime and others. And it should be extra cautious when invoking terrorism in conflict-related sanctions regime due to the interplay with broader CT measures. And for that, some stronger guidance, monitoring, assessment, and lessons learned on implementation practices of states would be helpful. I want to end by saying that while sanctions require a case-by-case approach, compliance with IHL in armed conflict does not, and the Security Council itself has recognized that multiple times. So it is now fundamental that all sanctions regime follow suit and be designed in accordance with IHL. Thank you very much for your attention. Back to you, Jillian.
Thank you so much, Agathe. And I think as both Sophie and Agathe forecasted for you, of course, some of their recommendations overlap. But that's for very many good reasons, including that these regimes overlap in some important ways and in other ways they don't. So our final speaker before we turn to our discussion and question and answer session will be Leah van Broekhoven, who's the Executive Director of the Human Security Directive and another one of the authors from our edition. She'll focus on sanctions-related humanitarian action as primarily carried out by non-governmental organizations and other civil society groups, and some more national level activities that sort of further the sanctions-related humanitarian action and compliance. I'll turn the floor to you now, Leah.
Thank you very much, Jillian, and thank you to the organizers and to my colleagues who were for their very insightful presentations. Happy to be here. As Gillian was saying, I would like to give a perspective from civil society, and especially how humanitarian NGOs have been affected by the UNCT resolutions, related sanctions, but also the anti-money laundering and countering terrorism financing standards that are developed and monitored by the Financial Action Task Force, an entity that was already mentioned by Thomas. The confluence of these resolutions, sanctions, and AML-CFT rules have led to over-compliance by banks and over-compliance in their due diligence and know your clients procedures of NGOs that deliver essential support to people affected by violent extremism, protracted conflict and war, and to over-regulation by donors and governments of these NGOs with the aim to mitigate terrorism activities and terrorism financing activities, with the result that the chain of humanitarian aid delivery and wider actions have become fragile and in some instances is broken. And this is also acknowledged by the previous speakers, by Nas and by the others too. Let me go into the overcompliance by financial institutions. One of the most notable effects of the AML-CFT standards by the FATF has been that financial service providers, banks, and payment service providers have become obliged entities to report on suspicious financial transactions, including transactions to sanctioned persons, organizations, and countries under the UN and other counterterrorism regimes, to Financial Intelligence Unit for potential criminal prosecution cases. Financial institution banks thus act as gatekeepers to prevent the facilitation of money laundering and terrorism financing through the international payment system. This has led to banks having become extremely risk-averse to humanitarian and other civil society organizations that are active in sanctioned environments and high-risk conflict environments. The phenomenon of de-risking by banks, also mentioned by the previous speakers, has been an agenda item in many discussions nationally and internationally in the past 7 years or so. And still, it's an issue and it remains to be a more serious issue. Then we have the over-regulation by donors, bank regulators, and bank supervisors. Coupled to the de-risking caused by over-compliance by banks, and that has led to financial access restrictions for NGOs active in the humanitarian space, we see another phenomenon that has been discussed in various forums in the past years, and that can be partially contributed to the AML-CFT standards, counterterrorism resolutions, and related sanctions. That is over-regulation by governments or intermediate donors, international non-governmental organizations, of civil society organizations that are operating on the ground in conflict areas or in sanctioned environments where illicit groups are active. Donors put CT, counterterrorism and countering terrorism financing clauses in contracts with the aim of preventing the risk that payments and material support end up in the hands of those that are on sanctions lists. When it concerns countries where local organizations are crucial for the delivery of humanitarian aid or pivotal to the protection of civilians, and where sanctioned leaders or governments rule, it are these local organizations active on the ground that carry the brunt of the counterterrorism resolutions, sanctions, and AML-CFT standards. They not only carry the risks, but also all the requirements to manage the risk, such as the vetting of service suppliers and even beneficiaries, which some donors nowadays demand from them. This requires a level of risk management sophistication that local, often small organizations and their partners cannot comply with. Or in the case of beneficiary screening, this is a red line organizations will not cross due to the humanitarian principles they uphold. So-called downstreaming or offloading of counterterrorism and sanctions requirements through contractual obligations is causing local organizations to accept contracts, although they run the risk of not being able to comply with the requirements and therefore are liable for criminal prosecution, or not to accept these contracts, which put the delivery of aid at danger, as many international NGOs depend on their local partners for humanitarian action, or the provision of humanitarian aid on the ground. Then we have authoritarian leaders that legitimize the suppression and dissolution of local civil society organizations that provide humanitarian assistance because they are often also critical of the leadership. because these organizations operate in the vicinity of listed group, have knowledge about anti-terrorism operations by the government or military, and of terrorist groups, or are by association considered to be terrorists and therefore listed by the government on sanctions list. We see that international AML-CFT standards by the Fatah are abused by governments for the suppression through overregulation and ultimately the dissolution of these civil society organizations. In some countries, it goes hand in hand with laws that prevent foreign financial support, including humanitarian support for these NGOs. In short, we can say that humanitarian or civil society are squeezed between the heat from below and the fire from above. These are all negative trends, but there is a bit of positive news though. The positive news as expressed by the previous speakers is that the international community, the UN, the EU, the Fatah, have come to realize that systemic change is needed to prevent more harm to humanitarian action caused by the interpretation of and compliance with the CT resolutions, related sanctions and AML-CFT rules. You mentioned already, my previous speaker mentioned already UN Security Council 2462 and the humanitarian exception for Afghanistan and their testimony to some positive developments, although it's still far from perfect. And also the policy papers that CTED, the Counterterrorism Executive Directorate, has issued about international humanitarian law is helpful in this regard. Then we have the work, I think, invaluable work of the UN Special Rapporteur on Counterterrorism and Human Rights, who also has repeatedly addressed the importance of international humanitarian law compliance within this counterterrorism framework. However, when it comes to changing now long-standing practices on financial institutions, their regulators and supervisors and donors, efforts need to be stepped up. The existence and incremental development of multi-stakeholder national roundtables, as they exist now in the UK, the Tri-Sector Working Group, the Netherlands, the Roundtable on addressing financial access restrictions, the US and France, and international regional dialogues about, for example, Syria, which was organized by the EU ECHO and the Swiss government, and the Humanitarian Aid and Sanctions Initiative led by ICAMS, a network of anti-money laundering specialists, are positive examples of stakeholders coming together, understanding the problems, building trust, and identifying solutions that are practical and at the same time push for systemic change. So they marry, in some of these roundtables, the normative with the technocratic solutions that we both, I think, require. The lessons learned from these dialogues are twofold, I think. Without the participation and commitment from supervisors and regulators of financial institutions for an exception of humanitarian actions to high risk and sanctioned countries, or for a more risk-based approach, which would result in an exception or a lighter due diligence counterterrorism regime for humanitarian organizations, banks and especially correspondent banks will remain risk-averse to banking humanitarian organizations, especially the ones that are active on the ground. And without a joint effort of donor governments to take on part of the risk related to the compliance with counterterrorism resolution sanctions and AML-CFT rules, international NGOs and their local partners will have to continue to carry the risk management brunt with serious hurdles for especially the local organizations. Risk sharing is not only an option but is a must if governments are serious about timely aid delivery to and protection of populations that rely on humanitarian actions. NGOs and banks are not able to solve financial access restrictions on their own. NGOs cannot address the overregulation on their own. We need political and policy support from policymakers and regulators. And I stop here and happy to discuss further with you and also tell a bit more about elements that make dialogues, multi-stakeholder dialogues, to address the sanctions and CT regimes and the impact on humanitarian aid further with you. Thank you very much.
Thank you so much, Leah, and thanks once again to all of the panelists for their presentations so far, and for very graciously sticking each of you very closely to the time that we asked you to stick to. So we've received a few questions from the Q&A, but I'm going to jealously guard my role for just a moment and kick off the Q&A a little bit first. I think a theme that's come up across every single presentation has to do with how you can formulate exceptions, exemptions, and other language in these sanctions regimes to better protect humanitarian action, whether that's in a more transformative approach or a more technical one or anything in between. So I have a question that I'm going to pose to a few of you, and really any of you could speak to it honestly. But I want to hear your thoughts on the extent to which humanitarian exemptions and exceptions and other language are created equal, and assuming that they aren't, what you prioritize. So Agatha and Sophie both talked about intent-based language and compliance-based language. We talked about different measures that can be put in place to ensure humanitarian imperatives are put at the forefront versus protected almost as an afterthought. So perhaps I can ask first for some thoughts from you, Agatha, since you spoke about this yourself. But what would an ideal set of exemptions or exemptions look like? Because you also talked about the harmonization of those and how you can think about harmonizing them well so that they apply well to multiple regimes.
Sure, thank you very much for the question. So in general, we consider that there are three types of exemption. One that is like a standing exemption, which can also be called an exception, which carves out the legal space for humanitarian actors and activities without any prior approval needed. Then we have an exemption by request or a derogation. And here, such exemption requires humanitarian actors to apply for the permission to conduct their activities and sometimes through the intermediary of a state. And a third type of exemption is the exemption by notification, which is in the UN system mainly used for arm embargoes. And so for the question, for the purpose of our discussion, clearly the preferred option is the standing exemption, which is also called the exception. And why is that? It's because the derogations raise several issues for humanitarian actors and humanitarian action in general. They cause delays on the process of deliveries of humanitarian action. There is problems also for the impartiality of humanitarian actors, and they add a layer of consent, which is not foreseen by IHL. And so a type of like standing humanitarian exemption like can be found in the Somalia sanctions regime or in the Taliban sanctions regime is the preferred option. And we've seen that in the recent discussions within the council, there's been actually type of new emerging questions as to whether like this exemption is actually a standing exemption is actually the best way forward. And many council members are asking whether there is a middle ground that exists between a humanitarian exemption and a humanitarian exception. Maybe we could use an exemption by notification. They're also asking whether to incorporate standing exemption for some armed groups only. And finally, whether humanitarian exemptions should be time bound. So I do not have these answers yet, but one of the recommendations that I put forward in the IPI report is really for our community of independent experts, but also for humanitarian organizations to issue independent opinions on advisable forms of humanitarian carve-outs in UN sanctions regime, so that we can be ready to inform future discussions and negotiations on those important questions. I'll stop here for now. Thank you.
Thanks so much, Agatha. That's great. I was wondering, Thomas, if I can sort of now put that question to you, but with a bit of an added focus. So in your remarks, you talked about needing to make a careful assessment of why humanitarian actors face challenges in complying with sanctions. And you talked about a few factors: the design of sanctions measures, risks of over-compliance, donor governments that work to go beyond what sanctions require, and deliberate over-implementation for individual states or actors' own interests. So I wonder if the specificity of those questions gives you a different perspective on the value of standing versus particularized exemptions and exceptions. Maybe it doesn't, but if it doesn't, I'd be curious to know why as well. You're muted, Thomas. Sorry.
So I thought you were going to unmute me. Sorry about that. Yes, in terms of thinking about how to address the issue, and I do take Naz's opening point about, do we need a fundamental rethink of these issues, or are there technocratic solutions? And I think maybe overly pragmatic, but I think we need some combinations of both, actually. I think there needs to be, and I think we've already seen a fair amount of consciousness raising about the issue, which is why I said I think it's becoming the fundamental legitimacy challenge to the instrument of United Nations targeted sanctions today. And I think it's close to being comparable to the kinds of issues that were raised by the Qadi case and the due process concerns that were raised in the first decade of this century relating to UN sanctions. But I think we need to go beyond Security Council language reforms. I mean, that's certainly, I'm not arguing that it shouldn't be done, but we need to go beyond that. And I think also beyond just coming up with the ideal exemptions or exceptions regimes and carve-outs. And I guess in terms of thinking about this larger issue, and I was emphasizing the complexity, there are different reasons. And I suppose while some harmonization is a good idea, case by case might be more efficacious only because you would address the particular concerns or problems. So let me get very specific and say, if we're talking about Yemen, which clearly is experiencing a humanitarian crisis, we need to focus on the regional foreign policy dynamics. We can't just change the Security Council language and hope that things improve. So that's why I said that the particular causes and particular contexts should be addressed directly. That doesn't mean that there shouldn't be reform and change. But let me, a part of my presentation that I didn't give, which focused on sort of clusters of different ways of addressing the issue. And some of it repeats what Naz and others have said are already in the recommendations. But let me just turn briefly to a couple of different avenues for pursuing beyond just the exemptions, although I'll mention those as well. One, and I guess this is the argument about dialogue, or make a sincere and transparent effort to conduct forms of due diligence to ensure that the fundamental purposes of the sanctions regimes are recognized by humanitarian actors, and good faith intention not to compromise those fundamental purposes through their significantly important humanitarian interventions. And that's why these dialogues with principal regulators about how to navigate their systems of restrictive measures is, I think, it's not the only answer, it's not sufficient, but it's necessary perhaps. We've already heard specific recommendations for how to take advantage of existing exemptions and exceptions. I don't think it's going to be possible to harmonize across all of the different UN sanctions regimes, but at a very minimum, we should be able to make it easier to find out about exemptions and exceptions and how to get to them. And I know UNU has done an important paper listing regime by regime, a paper by my colleague Rebecca Brubaker, regime by regime, how to obtain them. And it's something that we're trying to do with the UN Sanctions app and trying to put direct links through the app to to the current committee exemptions and exceptions procedures. Another point, and this has come up on focusing on the language, but use the periodic reviews of the Security Council resolutions to try to extend the language of exemptions in contemporary Afghanistan to other regimes. And that's something I think most of the participants in this would agree to. More controversial, I think, is the idea of it's not the final, it's not the best solution, but creating white lists of prominent international NGOs automatically exempted from some of the due diligence reporting requirements of existing regimes. It's not going to solve all the problems. It will, I understand, create new ones, exacerbating inequalities between international and local NGOs. But in emergency situations, the ideal may inhibit the achievement of the essential. So have not only those lists of international NGOs, but also financial institutions. And finally, to be perfectly candid, I think most of the problem stems from United States regulation. It's really the Office of Foreign Asset Control. That's when you talk to bankers and other financial institutions around the world. Everyone is looking over their shoulder at potential challenges coming from the Office of Foreign Asset, more than challenges, penalties coming from OFAC. That's what's motivating it. So to have this conversation, and I'm not trying to say give the US this privileged position, but the US regulatory regime and the mechanisms, the monitoring, the enforcement that's there is, I think, what's profoundly driving this. So have them in the room, talk with them, sit down and explain the situation, And I'm not trying to reinforce American hegemony here, but they are the 100-pound gorilla in the room. They need to be engaged. And I've seen a couple of what I would say are successful workarounds that worked because of the direct engagement. One would be the Swiss humanitarian channel. The other would be the efforts made to try to get funds to actors working in the DPRK. And those two initiatives, in basically using cash couriers in the latter case, are both ones where they were sitting down directly with OFAC. So I think one needs a multifaceted strategy to address the larger problems, one that's not only context specific, but multifaceted. Thanks.
Thanks so much for that, Thomas. That brings me to a point that I'm going to hold off on for just one moment, which has to do with monitoring. We also received a question about monitoring in the Q&A, so I'm going to get to that, which you raised as well. But first, I want to just turn to Naz. Given that, Naz, in your first remarks, you sort of took a more transformative approach to these questions. I wonder if you see this the same way as the other panelists have spoken so far on the exceptions question.
Thanks, Jillian. Yeah, and I want to preface this by saying we have worked with a number of colleagues in government and NGOs and in UN agencies who have done incredible work attempting to secure exemptions and exceptions in a variety of regimes. And I want to be clear how hard that work is and how much I respect those efforts. But I want to say it is really striking to me that this is where we are in this conversation in 2022, right? So we are talking about the idea that it is the responsibility of humanitarian actors to determine, to have apps, to have trainings. Where is every regime? Who can you go to attempt to understand what is the specific case-by-case means through which to justify your activity? And what I mean when I say strange is we sometimes, I think, make the mistake of comparing this issue to the human rights challenge. And there are many similarities, right? We talk about human rights law, we talk about IHL, but I really want to emphasize here, the bulk of humanitarian activity is funded by governments. The bulk of requests that we receive for assistance in understanding the legal regime underlying sanctions is from government agencies who don't understand their own government's approach to these regimes, UN bodies funded entirely by governments, and humanitarian NGOs funded almost exclusively by governments. When you have the head of major UN humanitarian organizations going on television and saying, I beg of you, states, I beg of you, Security Council, do not impose restrictions on us that will cause people to starve. We have a very unusual regulatory scenario here. This is not about civil society asking for space to resist. This is not about NGOs coming together from the grassroots to say, we find these regimes to be restrictive. This is about a multi-billion-dollar system of assistance to people suffering in armed conflict that is built on decades of government policy and intergovernmental decision-making about what their priorities are, that is being undercut by a relatively new kid on the block here. And I think the key here is, how do we frame these requests? So is it that the job of the humanitarian actors, and I do not mean here NGOs, I mean government humanitarian actors, to go and ask each and every of the 17 regimes for their specific exemptions to make case-by-case appeals? Or is it rather that we say, why shouldn't the restrictions be time-bound? Not the exemptions, the restrictions. Why shouldn't the regimes that seek to restrict efforts that have been supported by governments large and small, by decades of law and policy, justify when they want to restrict humanitarian activity? And I absolutely agree that the US is the key player on certain elements of this. But I would also note that it's very familiar to many of us who have been doing this for a long time to hear the argument that when you try to approach Security Council sanctions, you hear, no, 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 no. This is about individual governments and their specific domestic law. When you then approach individual governments to talk about their domestic law, they say, no, no, this is the Security Council. This is a global regime. So my point here is just to say, I think if we remain in the arena of let us prove that the effect is so serious that it is the fault of the regime, I think Thomas's comment at the beginning was absolutely right. You will fail. The causal link is too difficult to prove across the board. If you make the argument that it's IHL trumps all Security Council regimes, Thomas is right. The legal argument in many cases will fail. But I think rather the idea is, how can we reground this in saying this is a moral commitment, a political commitment that the states, member states of the United Nations and political communities of the world have decided matters when we are in situations of deprivation. And we have a regime that is bit by bit, piece by piece, chipping away at that commitment. How do we respond to that, I think, is now the question. And it doesn't mean shelve all efforts to gain exemptions or don't ever ask for exemptions again. But I think it means really asking ourselves, where is the leverage and the power here? And are we adequately grounding our positions from a place of strength rather than from a place of begging to be allowed to do something that governments have already committed to do?
Thanks, Naz. Glad to see. I was not disappointed to see that you would have a counterpoint to make there. Leah, it seemed like you were nodding along and maybe had something to add as well. So I want to give you the floor here too.
No, I think it's very difficult to add to Naz. I think I totally agree with what she's saying. And this is also a discussion. It's not that I'm agreeing, but this is something which comes up in the roundtables as well. There are people in the roundtable that have to play along with a lot of these counterterrorism and sanctions related requirements, because they just want to continue with their humanitarian work, and they will go at lengths to show that they are not, that their money, that their services do not end up in the wrong hands, right? Between inverted commas. And I understand these bigger INGOs that all have risk management tools in place now, because they just want to continue with the work. But I totally agree with Naz, there's an underlying discussion here. And I don't, we need to really be strong as NGOs working on humanitarian action, but also on peace building, often taking place in the same sanctions arenas where humanitarian aid is necessary and that are under sanction or are under CT regimes. So it's also about, it's not only about aid delivery, it's also about talking to the enemy, right? Talking to listed groups. So peace builders are also immensely cut off from all the possibilities that they normally do. It's talking to the enemy. And I think I'm happy there is a small, I think, opportunity now in the international humanitarian law paper that CTED produced, which also talks about human dignity, not only about shelter, medicine, food, and so on. So I think the human dignity, which is connected to a moral framework, and I think this is about the moral framework, is something we need to push. And we also need to hold our ministries of foreign affairs to account in this respect. Because Nash, you're absolutely right. Most of the humanitarian money comes from governments. Humanitarian ministries of foreign affairs, humanitarian departments for stability and humanitarian aid that want this humanitarian action, humanitarian aid to push through, to happen. But they cannot stand up to those in the same department that are wearing the hats of the counterterrorism policies, counterterrorism objectives, and so on. So there is a huge policy incoherence amongst all the donor governments in this world. And I think we more and more need to hold them to account, to step up their efforts, because I'm absolutely in agreement with you that the whole, let's say, unintended and intended consequences of this whole CT regime, the sanctions related to counterterrorism, and the AML CFT regime should not fall on the plates of NGOs, their local partners, and also not on the private sector, to be honest. I think political will and political courage is needed now. So yes, only to add to your, to your excellent intervention there, Nas. And Thomas, we've met last week where I learned a lot about sanctions from you. And I'm not against technocratic solutions per se, but the technocrats will always say, give me the proof, more research, more evidence. And to be honest, I don't think we need more research to prove there is a big issue here in the undermining of the humanitarian imperative. So I stop here. Thanks.
Thanks so much, Leah. So for the sake of touching on a few other topics in the Q&A, I'll push us to change gears a little bit now. I would like to bring up a question that's come up in the Q&A in a few different ways. It has to do with the monitoring of sanctions and their effects. So impact assessments of sanctions, who carries them out, and why is it not other actors that are currently carrying them out? One of the questions in the Q&A specifically framed it as, why is it not humanitarians, for example, that do the impact assessments of how sanctions impact humanitarian action, or perhaps better by independent actors who are sort of affiliated with neither set of imperatives, humanitarian or sanctions-oriented imperatives. So Sophie, perhaps that's something you can address as a starting point, and then we can see if anybody else wants to jump in too.
Yes, of course. So yeah, independent body monitoring the or doing sanctions impact assessment. That has already been the case. Academia, for instance, is an independent body, right? So when you have reports coming from academia, it's already been the case, trying to show or gather evidence of impact. And that's and measuring the impact of sanctions has also already been done by many NGOs. As Nas said, there is a growing body of evidence for the past decade or so. But despite this growing body of evidence, the question of adverse impact remains contested. So maybe now we need evidence to come from sanctions bodies as well, or sanctions affiliated bodies as well. For me, it comes down as well to expertise of sanctions, methodology, and financial and human resources. And sometimes NGOs may lack either the expertise of sanctions, not all of them, but some of them may lack it. And some of them may just lack the financial and human resources to do this own impact assessment themselves. But if this is taken by a panel of experts or by the Security Council Affairs Division, for instance, they are used to doing that type of work. They already conduct assessment of sanctions effectiveness. They already conduct assessment of violation of sanctions. And for some of them, they already have a methodology in place to do impact assessment. For instance, they used to do that. I mean, the 1267 committee used to do that in Afghanistan before the regime was split between al-Qaida and Taliban. They used to do that in 2000 or so, and they did that again in 2015. So the structure of either panel of experts or Security Council Affairs Division already have kind of the stamp of approval of the Security Council. And yet they are supposed to be independent from the council as well. So it would require to increase their financial means, and maybe also the number of staff working on these issues. But if it's coming from them and they have an agreed upon methodology, and if it's coming, like it's bringing back a sanctions expertise in the assessment, it may also gather more consensus among UN Security Council members, especially if the findings go alongside the same ways than what has already been found by NGOs and academia. That's it for me, but yeah.
Great, thanks so much, Sophie. Thomas, would you like to jump in here as well?
Yeah, I'd just like to make a comment about the monitoring within the UN system. Of course, that would rely on the panels of experts that are appointed for the different sanctions regimes, for almost all of the sanctions regimes. And one very practical point is related to the existing panels of experts. And it's a simple recommendation that whenever the cumulative sanctions reach a certain level of non-discriminating impact, that is beyond individual designations, when they get to a certain level at the sectoral level that are likely to have broader impacts, adjust the mandate of the panels and give them, or bring on a humanitarian expert who's responsible for adding in the regular reports information about the difficulties of achieving humanitarian action goals. So it's a simple matter of adjustment of the mandates and adding an additional person, but not necessarily in all sanctions regimes, because some are extraordinarily narrowly targeted. So it's only in those that I think have sectoral reach beyond a certain level. And in some of our recent research, we've been looking at what we describe as the scope or the scale of discrimination of different sanctions regimes. And I would argue if they get above a certain level, what we call a level 3 in the 7-point scale, then you should add a humanitarian expert and make that part of the mandating and regular reporting. So there's an internal reform idea.
Thanks so much for that, Thomas. So we've received another question in the Q&A that I'll read out in full because it's a longer one and I want to present it in good faith. So the question reads, it's about precedents in Security Council resolutions, and it says to flag that the earlier 1267 resolutions, including both 1267 and 1333, included among the tasks of the 1267 committee to report on the humanitarian implications of the measures that the resolution imposed, and also reaffirmed the need for sanctions to contain adequate and effective exemptions to avoid adverse humanitarian consequences on the people of Afghanistan, and that they be structured in a way that will not impede, thwart, or delay the work of international humanitarian assistance organizations or governmental relief organizations providing humanitarian assistance to the civilian population in the country. So after posing that sort of context, the participant asks if there are any lessons to be learned from the early practice in implementing these provisions. If there are any lessons, and if there are, what are they? What can we take from those going forward in future resolutions or future sanctions work? And maybe Agath, you can jump in first on this one, and then we can see if anybody else wants to add.
Happy to, thank you. So yes, it's actually very interesting to see that in the early days of the 1267 sanctions regime, which at the time only covered the Taliban, it did include a provision that could be considered as a precursor to humanitarian carve-out. And the resolution at the time allowed an exemption to the no-fly zone if the particular flight had been approved in advance by the committee on the grounds of humanitarian needs. And this exemption was then removed once the air embargo was terminated in 2002. So indeed, it would be very interesting to have some lessons learned about that time and about the way the Sanction Committee monitored this provision and the impact on humanitarian aid. I'm not directly aware of one. Actually, if someone is, I'd be very interested to definitely see those, but definitely to discuss the lessons learned about that time would be very, I think, helpful and interesting. And as Sophie mentioned, it's actually not the only time that the Sanction Committee and the panel of experts were asked to review and to monitor the impact of sanctions. In 2015, in the 1267 regime, which at the time expanded to Daesh and al-Qaida, the Security Council also requested the monitoring team to report on unexpected challenges and unintended consequences of the regime. And this resulted in the monitoring team's engagement with the humanitarian sector and inclusion of financial de-risking question in its 2016 and 2017 reports. So again, important precedents here. And however, this is not the case anymore. So I agree with Sophie and Thomas that this is now about the council. This is for the council to redirect and to make sure that it reprioritizes the mandate of the monitoring team in this regard, and that it makes sure that it has the right resources and expertise to do so. Thank you.
Great, thanks so much. I got Thomas, did you want to jump in on that as well?
Very, very, very briefly, I just wanted to suggest that I think this suggested changing the language of the resolutions is not sufficient in and of itself. I mean, I think that's a more cynical lesson to determine from this, the fact that yes, it was there in the past. It's not, I'm not saying it shouldn't be done. It's necessary to be done, but this is, I think, another argument for a more multifaceted strategy to address what Naz and others have described as a systemic problem. Thanks.
Great, that's perfect. So look, we're nearly out of time. I want to give each panelist a chance if they have a final thought they'd like to add, perhaps to inspire final thoughts. so much of this conversation has dealt with how we could possibly reconcile, or if we can reconcile, the tensions between compliance with these measures and humanitarian principles and humanitarian imperative. That is a big, big open question to throw for a final thought, but if each of you want to go for a final thought on that before we wrap up, and then we can end on time, maybe we can go in the same order that we initially did the panel in. So Naz, if you'd like to say a closing remark.
Yeah, thanks. Just to say, I think that is the challenge, but I think that the kind of conversation that we're having today, and particularly, colleagues both who are delivering the kind of really granular, specific research that helps us to better understand the nature of these issues, right? There is this tendency that I think we sometimes speak in generalities, and we aren't looking at the very specific regimes. So I think the reports that we've linked to, I really recommend to everyone to look at those. But also, I think the perspective that Thomas has brought, which is crucial, I think, for those in the humanitarian sector to hear, that this is a set of questions that we really need to reflect upon. So I think discussions like the one we're having here make me feel like there is hope and opportunity to have these discussions based on the real stakes and the real political values underlying them. So thanks to everyone.
Great, thank you, Naz. Thomas, you're next.
Okay, please don't, I hope people didn't misunderstand or interpret my remarks. I'm certainly, by talking about sanctions as I did, I'm not trying to say there isn't a problem, but that it's a very complex problem, and that clearly sanctions contribute to a challenging environment for humanitarian actors. But again, they're not the only cause of the challenges facing the actors. Each conflict context is different, and as I said earlier, try to determine the core source of the problem, whether it's design, implementation, or donor country requirements, and then tailor reforms in a multifaceted way to address the specific conflict context. And I think pursuing a multi-solution strategy, beginning with constructive engagement with regulators, reform of the language of sanctions design, experimentation with new alternative mechanisms for financial transfers, which we didn't talk much about, and a case-by-case identification of key international non-governmental organizations and financial institutions to handle the core humanitarian relief operations. So I think it's there is some progress. It's interesting to reflect on the fact that even though we had language in the past, it wasn't necessarily cumulative. We need to go beyond that. But I think there's some room for optimism about the possibility for change and reform in this very, very important issue domain. So thanks.
Thanks, Thomas. Sophie, now to you.
Sure. Then it's just maybe a very general message around coherence, right? I mean, states drafted the Geneva Conventions, they drafted the rules regulating humanitarian activities, and they mandated humanitarian actors to take on humanitarian activities and to comply with impartiality and so on. And yet now states are adopting sanctions measures, and in a lot of cases, humanitarian actors kind of find themselves between two body of laws that can clash, and they don't know if they have to abide by sanctions and so comply with one set of international law created by state, or if they have to abide by AHL and comply with another set of international law that was also created by states. So it's a little bit of a schizophrenic position that in the first place is coming from states. So that's just a message of coherence from me.
Great, thank you so much for that, Sophie. Agathe, now to you.
Yeah, thank you. Well, I wish to reiterate that the Security Council has made clear that there is no contradiction between its counterterrorism objectives and protecting impartial humanitarian activities. And we see that much progress has already been made in this discussion. So it is important to pursue this dialogue between different stakeholders and continuing taking concrete steps to strike the right balance. Thank you for having me.
Thanks, Agathe. And finally to you, Leah. Just muted.
Sorry. I think these type of discussions in this, this forum are very important. There are many, I think, forums at the moment where this discussion takes place more from a counterterrorism framework. But I think this confluence of sanctions, counterterrorism, AML, CFT That's very important because it impacts humanitarian agents and peace builders and human rights activists on the ground. And there are a few, dialogues ongoing, for example, organized by the Global Nonprofit Coalition on the Fatah, where we also discuss humanitarian imperative and how it's being undermined by sanctions and CT measures. So please do join www.fatfplatform.org. And I also think, because I'm not a sanctions specialist, I'm more of a practitioner, and I know a little bit about AML CFT rules, but I think you as sanctions specialist, please do take part in these forums, whether it's international or at national level. I think your voice needs to be heard there too. So thank you for the opportunity to be here. Thanks.
Thanks for that, Leah. And thanks again to all of our really excellent panelists for their incredibly thoughtful and well-spoken remarks today. And thanks to the audience, your engagement was really excellent. The questions you posed in the Q&A fueled this entire discussion. And that's rare. So often it's left to the person in my role to fill in those gaps, and I had no gaps to fill. So thanks everybody for your engagement, your interest in this topic, which of course is very important to all of us. We hope that you find the publications that are associated with each of our programs to be useful to you as you continue to work on these topics as well. And for all of you all around the world, have a great rest of your morning, afternoon, evening, and have a good one.